The states, Article 4. States have the power to create and enforce their own laws. Article 4 of the Constitution describes how states should interact with each other. Each state has to respect the laws and court decisions of the other states. If a criminal flees from one state to another, the state where the crime was committed can request that the criminal be returned to face charges. This is called extradition. New states can be admitted to the Union with the authorization of Congress and the President. All states must have a Republican or representative type of government. Sorry, states can't have kings. Amending the Constitution, Article 5. The Constitution is not set in stone, and Article 5 describes how it can be changed. A change or addition to the Constitution is called an amendment. Given what you've learned so far, do you think the Founding Fathers made it easy or difficult to amend the Constitution? If you guessed difficult, you're right. You read all about it on the next page. Supreme Law of the Land, Article 6. Federalism is the idea that the national government shares power with the state governments. But what happens if a state law disagrees with a national or federal law? Article 6 states that the laws and treaties of the U.S. government are the supreme law of the land. If a state disagrees with a federal law wins. This article also requires officials working in the state and federal governments to take an oath to support the Constitution no matter what. Ratification. Article 7. Article 7 states the Constitution could not take effect until at least 9 out of the 13 states approved it. Back then, there were only 13 states. Each state held its own convention to discuss and vote on the Constitution's plan for government, but getting approval wasn't easy. Some people thought the 7 articles weren't enough. After much debate, it was agreed that 10 amendments would be added to the Constitution. These amendments, called the Bill of Rights, would list specific rights not already mentioned in the Constitution. This put people's minds at ease, and the Constitution became the law of the land in March of 1789. The Bill of Rights was added in 1791. The amendment process. The Constitution has only been amended 27 times in all these years. Does that tell you anything about how easy it is to change? Believe it or not, there are only 2 steps to the amendment process: approval in the U.S. Congress and approval by the states. But these steps are hugely difficult, especially the second one. Getting members of Congress to agree on something is hard enough, but getting states to agree, that is an awful lot of agreement. With so much approval required, changing the Constitution can take years. Here are the ways it can be done. So few amendments, so much time. Hundreds of amendment proposals are introduced into Congress each year. Only 33 have ever received enough votes to actually be proposed. Of those, 27 were ratified and are now part of our Constitution. The first 12 amendments were proposed only a year after the Constitution took effect. Only 10 of those were ratified by the states. They became the first 10 amendments to the Constitution, and we call them the Bill of Rights because they define many of the rights guaranteed to U.S. citizens. The 27th Amendment was actually one of those original 12, but it wasn't ratified until 1992. The 21st Amendment, which repealed the prohibition against alcohol in 1933, was the only amendment where states held special conventions to ratify the proposal. That is the final part of the reading. Go ahead and use what you learned to answer the corresponding questions in today's lesson.